All right, so how many of you have received RFEs, whether you have a H-1B petition or an L petition? I feel like we all should hug each other and just really give each other support. It's been a really, really tough year, especially 2017, and I'm hoping it'll be different in 2018. We have seen a significant change in how applications are being adjudicated. And it has a lot to do with the current policies that the current administration has implemented. And I'm going to first provide a context as to why we're seeing this increase in RFEs. And we've already mentioned some of them, so I'll just go over it very quickly. So in March 6th of 2017, a few months after President Trump came into the office and we heard all this news about the travel ban and everything, there was a memo that was issued called the Extreme Vetting Memo. And essentially what it stated was the administration would implement procedures to enhance the screening and vetting of applications for all visas and other immigration benefits. This was in March of 2017. Then in April, we saw Buy American, Hire American, the executive order, basically stating that to protect the interests of U.S. workers in the administration of our immigration system, the administration would propose new rules and issue new guidance. And this is what we've been seeing since that time, new rules, new guidance, the recession of the deference guidance memo that Laura mentioned earlier, where in the regulation it states if you have a petition that has already been approved, there should be deference given to that approved petition. And essentially, there was a memo that stated, no, that is no longer true. So what that means is we can't take it for granted that someone who was previously granted H-1B status or L status is going to be approved again. And it's really changed our practice and how we interact with you as employers or sponsors of these petitions, where we're asking for a lot more information than we ever did in the past. Just to give you an idea of how difficult it has been, in 2017, there was a 44% increase in requests for evidence from January through August, and that included the H-1B cap period. H-1B approvals were the lowest in many years at 59%. So that's the context in which we're going to really now talk to you about what we're seeing in requests for evidence and how we can really partner together to overcome this. I don't think we can avoid it in many situations, but we can definitely partner to help you manage how we respond to requests for evidence. It's really part of what we expect in our practice nowadays. It's no longer a surprise, it's an expectation. So, Joseph, do you want to talk about recent trends in RFEs?
Yeah, sure. Let's
move to the
change
next.
that. So there are three of them that we put on the PowerPoint, and that the bottom one, Deborah and Lon just discussed. We had a lot of issues and continue to have them with employer-employee relationship RFEs. But I'll talk about kind of the top two. The level one RFE was something that came out fall of last year, and we received, USCIS was issuing thousands of these, and all immigration practitioners kind of faced these where they were saying that a position, an H-1B position, was too complex to be a level one wage. Or they were saying that the position is not a specialty occupation because a level one wage indicates that it's entry level. And so it can't be a specialty occupation then. And you could see that that reasoning is a catch-22. It destroys all definitions of specialty occupation and the corresponding wage level. We responded to those RFEs, I think, as a large group. All immigration lawyers kind of had a strong response to it. And actually, we've seen decisions come out of the appeals office for the Immigration Service that said that this reasoning doesn't apply, that just because it's a level 1 wage doesn't mean it also can't be a specialty occupation. And so that's one place where we've seen kind of a good outcome, but at the same time, I mean, this was causing a lot of stress for anybody applying for an entry-level H-1B position. And to give you an example of that, I think the one out of the appeals case, it was a geotechnical engineer that they were saying wasn't a specialty occupation because it was a level 1 wage. I think a geotechnical engineer does need a bachelor's degree, even if it's entry level. Lon, I think you'd agree with that, right?
Yeah, definitely. Actually, part of the definition of a specialty occupation in the regulations states that an engineer is a professional position, and so we've been able to rely on that. But you can see some of the example that Yosef provided. It just, the RFEs we're getting, it just doesn't make sense, and we apologize that we can't explain why it doesn't make sense, because that's just the context in which we're working when you're getting denials for teachers. I think we've seen some physicians, H-1B petitions that were also denied too, or I'm sorry, where requests for evidence were issued. So thank goodness for the most part, we've been able to respond and they've approved the petition. But as I've stated, RFEs is just part of everyday life for us right now.
And that second one on there, the stricter interpretations of specialty occupation, I think that's a more challenging one to overcome, because in that case, they're saying that a certain position doesn't require specialized knowledge in a certain, that's gained from a certain degree. And we've had some struggles, I think, with different positions, for example, a software tester.
Right. So the Immigration Service has stated that it views the Occupational Outlook Handbook as authority as to what is the minimum education requirement or entry into the occupation for a certain professional position. And we know that's not realistic, that we hire individuals to fill software developer positions that may have degrees in mathematics, various types of engineering degrees. And if it does not reflect what the Occupational Outlook Handbook states, we could expect a request for evidence. So knowing that, we have to be proactive and prepare for that beforehand. But that's what we're seeing in terms of stricter interpretation of specialty occupation, which is relying on this source that at sometimes the Immigration Service says, well, it may state that a certain degree is approved, but because it has provided alternative degree requirements, we don't think that's a specialty occupation because it doesn't require a degree in a specific field of study. So you can't win at all.
And
no
Lon,
matter what.
these are connected, I think, to the Buy American, Hire American initiatives, right? Because they're trying to take out certain occupations from getting H-1Bs.
I definitely think so. I think, what we clearly see here is the IT industry being targeted, and the decrease in H-1B petitions this year, we know very well what happened was we had an increase in H-1B cap cases because we do represent IT consulting company, but we represent many different clients where their need for H-1B cap cases has increased, whereas we've heard that many of the IT consulting company have just withdrawn from filing the H-1B petitions, and that's why I think we saw the number of 198,000 petitions, because I think there was basically evened out. Non-IT companies who are growing, who need workers, file many more H-1B cap cases, whereas many companies within the IT industry withdrew from it. So we're going to go to the next trend that we're seeing in addition to the H-1B, which is the L-1 for intra-company transferees. We've also seen trends in RFEs for L-1s, intra-company transferees, whether they're managers or individuals with specialized knowledge. And what has happened is USCIS recently issued a memo. Actually, it was a decision that we really liked. It was matter of G, and what it stated out was it stated or provided the requirements for a functional manager. And the reason I liked it was it finally gave us some guidance instead of being in the dark or everything's gray with immigration, clear as mud, as I say it. And we finally got some guidance, but it provided a stricter interpretation of what constitutes as a functional manager. So the employer can file a L1A manager petition if the individual has been employed abroad for at least 1 year and is being transferred to the U.S. in a management position. It can be a people manager position, or it could be a position where the individual is managing a specific function. And it laid out specific criteria that the employer now has to meet, specifically that if you're managing a function, it needs to be that you're not performing the day-to-day duties of that function, that there are other individuals in positions, whether they're direct report or indirect report, that are performing the day-to-day duties of the function, and you're just managing the operations of that function. So that was something that came out recently. For L1As, very similar to H1Bs, we now have to clearly state what are the duties and assign percentage of time for each of those duties. That is just what we now have to do. And if you're working with us on any of those non-immigrant cases, that's one of the first requests we make is please provide us with your job duties and also assign percentage of time for each of those job duties. And that is just to be proactive. Specialized knowledge we've always had difficulties with the U.S. Immigration Service regarding specialized knowledge, and that hasn't really changed. So, we continue to get RFEs. I got a RFE recently, even though we had an approval for this petition previously, asking as to how it meets the specialized knowledge requirement. And in this type of situation, what we really like to see are cases where the individual has proprietary knowledge. Perhaps they have knowledge about the company policies or procedures or software, and that's why it's specialized. Not all cases are like that, so we then have to show why are they a small percentage of employees or workers in the U.S. that may have this knowledge that others may not have We are also seeing difficulties, it's not RFEs, but blanket L petitions for those who have blanket Ls. Usually what that allows you to do is apply for the L1 at the consulate. And we love blanket Ls because we can avoid USCIS. We don't ever have to deal with USCIS. We prepare the petition and send the petition to the employee if they're abroad to apply at the US consulate directly for L visa. Well, what we're seeing is that some of the consulates are issuing non-approvable decisions, basically saying they're denying it, but they're not saying they're denying it. They're saying it's not approvable. And what that forces employers to do then is to file the petition at USCIS, which defeats the purpose of the blanket L, because the whole purpose of it is to make it faster and more efficient for international companies to transfer workers. So we're seeing that also, and that's in line with, when we file the case with USCIS, we're going to see a RFE. We just expect it. And so it's managing, trying to see what should we submit at the onset of a case and what should we submit, in response, what should we save to submit in response to a RFE. So Joseph, do you want to talk about how we can manage RFEs if we can't avoid them?
Yeah, I think you sufficiently scared everyone with all those RFEs and the possibilities for them. And RFEs are, stressful because they're the first step towards a denial of your case. And they give you a time limit for when you respond to them. So we wanted to talk about some ways to manage the RFEs that you'll get. And I mean, the first one, if possible, we want to avoid them. That's the level 1 wages present one example of how we can do that, which is if the wage is really close to level 2, maybe the employee's salary can be bumped up to meet that level 2 wage if you don't want to face the inevitable level 1 RFE, right?
Yeah, absolutely. And in line with that, also level 1, we are seeing an increase in requests for evidence for alternative wage surveys. Knock on wood, we haven't yet, but we are receiving reports from other practitioners across the country that they're getting requests for evidence questioning the underlying alternative wage surveys that are being used for their labor condition application. So what some of us did was, okay, let's not use level 1 then. Let's use the alternative wage survey to see if it will work. The Vermont Service Center, if you're in Minnesota, we file at the California Service Center. The Vermont Service Center was also already issuing RFEs on the alternative wage surveys. We have not seen it in California as much, but we're starting to hear about it, and hopefully we won't see it, and it'll be nip in the bud before we file our petitions or they get to our petitions. Where we're using alternative wage surveys. But that is why when we work with you, we need detailed job duties, right? We ask for detailed job duties. What are your requirements? In the past, our strategy was just to say, hey, a bachelor's degree is required because that's what a H-1B requires, right? And that's all we need to prove. But in these current times, that's no longer true, and we need as much information as possible. And also to make an argument, what are the beneficiaries' qualifications for the position? Because we're seeing RFEs regarding the fact that, hey, this individual does not have a degree related to the field. So what we've done is we've laid out, okay, they may not have a degree that exactly matches the occupation, but here's the coursework that they had in school that really relates to the job duties. So it's being proactive as much as possible, and it does take additional work, but I love winning RFEs. We get really, it never gets, it just doesn't get old. I think what I love about our group is we love the fight. We understand what your employees are going through, and that is why we're here. And, we'll do everything we can to help manage the case and win the fight, but it really takes partnership from you, with you, in regards to winning these RFEs. And so when we prepare a response to a request for evidence, we literally go through the request for evidence line by line. And even though you provided that information, I know we already provided the job duties. We already provided the percentage of time for each of the job duties, but they're asking for it, and we need to make sure we respond to each one of them. Anything else you would add?
And I think we've been very successful in those responses. But the reason we have to have a presentation on this is that there are going to be new RFEs coming out. We've already seen a few of them, and we'll have to give this again in the fall once we see what the new H-1B RFEs are going to be about.
Yeah, we expecting something new. Believe me, with the level 1 RFE, we were not expecting issues about wages, especially level 1, because, for years and years, we've been practicing under this belief that, look, a specialty occupation is the threshold here, and you only have to show that a bachelor's degree is required for it. And it's going to be interesting to see what comes out. I have to share with you, we've got tons of approvals for our HCAP cases without any RFEs, but we're thinking they're just waiting for or holding back on the ones that they're going to issue RFEs for. But we've been very happy this week. We got to enjoy any happiness we can get. And so we've gotten great decisions without any RFEs. But in preparing winning RFEs, we will go back to you and really ask for you to provide information to us that we probably haven't asked for in the past, and really talk to, for example, the manager of the individual to really understand how the position is complex and why it's a specialty occupation. We will be creative and think about resources that we probably would never have asked you before. Can you provide us ads from your competitors, and what are they requiring for the same positions? That's what we're providing to the Immigration Service. Looking at third-party resources. I've never heard of study.com, but I've been using it because it works. And I think they're just repeating what the OOH states or something like that, but it's gotten us approvals. So it's about being creative, but giving it our all in responding to RFEs in order to win them. And believe me, we celebrate every single approval that we get when we get an RFE.